Good day everyone, and welcome back to another episode in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule Corporate Employment Law, and in today's episode we will be unpacking what if an employer alleges an employee's appointment was procedurally flawed and irregular. Is termination justified? Believe it or not, this exact scenario played out in the Labour Court case of South African Social Security Agency versus Rowan van der Merwe. In this episode, we unpack how the Labour Court tackled this situation and what it means for an employer. Let's dive into it. This case kicks off with a job ad from SASSA for a practitioner, human development and transformation role, closing on 20 August 2021. It required an NQF level 6 or 7 qualification like a national diploma and applications using the Z83 form. The employee applied, confirming he'd completed his diploma in human resource management. His diploma was pending with the Department of Higher Education, which can take 3 to 6 months due to backlogs. At his interview, he submitted a letter from the institution at which he completed his qualification, though it lacked a date, signature or stamp, and SASSA's head office advised him to provide an affidavit confirming his completion, optionally with his academic record. He submitted the affidavit, though it's debated if he was told to include the academic record. The employee's appointment was approved on 10 January 2022 and he started on 1 February 2022. But a union complaint later triggered an investigation with findings delivered to SASSA in June 2022. The investigation found 2 issues. Firstly, the employee used an old Z83 form, though the new version was effective from 1 January 2021, and 4 shortlisted candidates did the same. The ad didn't clearly mandate the new form, it was just attached to the email, so SASSA's HCM department was at fault and applicants weren't to blame. Second, the employee didn't have his physical diploma by the closing date, but he'd completed it and hadn't misrepresented anything. Still, the investigator recommended rescinding his appointment and restarting recruitment. On 20 December 2022, SASSA gave the employee a choice: agree to set aside his appointment and return to his old role, or face a Labour Court review where they'd seek costs against him. The employee refused on 9 January 2023, noting he had made financial commitments, consulted HR beforehand, and was willing to find solutions. SASSA filed a review on 15 June 2023. The Labour Court ruled against SASSA. This isn't like a typical case where an employee is dismissed for misconduct. Here, the employee did nothing wrong. The court found the Z83 issue was SASSA's error, not the employee's, and the diploma delay was due to external backlogs, not misrepresentation. Since SASSA accepted the employee's affidavit and he met the job requirements, the flaws weren't serious enough to undo his appointment. The 12-month delay in acting weakened SASSA's case, and by the hearing, the employee had worked over 2 years, adapted financially, and performed well. The court held that demoting the employee would be unfair, while SASSA showed no harm in keeping him. SASSA's application was dismissed. In other words, termination wasn't justified. The outcome reinforces that minor procedural flaws don't justify undoing an appointment, especially without employee fault. Weighing prejudice was key. The employee faced severe harm from demotion after settling in, while SASSA suffered none, tipping the scales toward fairness. So, what can we learn from this legal drama? Let me give you some practical takeaways. Crystal clear job advertisements are non-negotiable. If you require a specific form version, make it explicitly clear. Don't assume applicants will figure it out from the attachments. Act promptly on procedural concerns. SASSA's 12-month delay was a nail in their coffin. If you discover issues, address them immediately. Don't punish employees for your administrative errors. The form confusion was SASSA's fault, yet they tried to make the employee pay the price. Consider the human impact. Courts will weigh the prejudice to both parties. If an employee has settled into a role and is performing well, think carefully before disrupting their life. That brings us to the end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me on ross@massconsulting.co.za. Until next time, bye-bye.